Over 70% of wealthy families lose their fortune by the second generation. Richard Pratt's $5.5 billion estate proves exactly how this could happen. Richard Pratt was an Australian business tycoon and at one point the country's fourth richest person with a personal fortune valued at over $5.5 billion. But when he died in 2009, his scandalous affairs with two mistresses, a former escort and another woman with whom he had a child, triggered an explosive legal battle over his billions. You see, despite his immense wealth, Pratt failed to properly document and legally formalize any promises or arrangements he had made to these women during their relationships. And his lack of a clear, airtight estate plan opened the doors to years of costly court fights between his wife, mistress, and daughter over who was actually entitled to what. And as an estate lawyer, I have a special interest in these kind of stories, so I've spent weeks digging into the details and legal fallout from this case. In this video, I want to share his biggest mistakes, how having not one, but two mistresses made this incredibly complicated, and how you can prevent finding yourself in a similar situation, whether you have a mistress or not. Despite his wealth, Pratt's failure to properly document any arrangements or promises made to his mistresses led to years of costly legal battles, draining millions from his estate. These drawn-out court fights could have been avoided if Pratt had taken some critical estate planning steps. One of Pratt's biggest mistakes was making alleged verbal promises of financial support to his mistress, Madison Ashton, without properly documenting them in legally binding contracts or trusts. Ashton claimed Pratt had agreed to set up a $5 million trust for her children, pay her a $500,000 annual allowance, and cover her housing and travel costs, and more. While the courts ultimately ruled that these alleged promises did not constitute a valid agreement, the fact that Pratt made such verbal assurances opened the door for Ashton to pursue a $10 million lawsuit against his estate. Even though she lost the case, it wasted substantial time and money on legal fees that could have been avoided. The lesson here is twofold. Wealthy individuals should be extremely cautious about making any promises of future financial support, especially to mistresses or partners outside of a marriage. Even verbal statements can potentially be used as grounds for legal claims later on. But if such promises are going to be made, it is absolutely critical that they are formally documented by experienced estate attorneys in an airtight, legally binding contract or trust. Putting everything in precise, written terms prevents any ambiguities about obligations after death. After initially losing her $10 million lawsuit against Pratt's estate in the Supreme Court of New South Wales, Madison Ashton appealed the decision. She claimed her relationship as Pratt's kept mistress was evidence of his intention to create legally binding promises. However, the Court of Appeal dismissed Ashton's appeal bid. The court ruled that the alleged arrangements between Pratt and Ashton failed to spell out important terms such as Ashton's obligations as the mistress, how long the arrangements would last, and the specific details of how the $5 million trust for her children will be structured and executed. The court also noted that Ashton had already received substantial gifts from Pratt during their relationship. But Madison Ashton wasn't the only mistress who attempted to make claims on Pratt's vast estate after his death. There was also his former mistress, Cherie Leah Hitchcock, with whom Pratt had a daughter named Paula. In his wills and trusts, Pratt reportedly left Paula a multi-million-dollar Sydney mansion and $22.8 million in shares. Both Hitchcock and her daughter also stood to gain an additional $5.7 million in shares to be controlled by a trust company. But Hitchcock and Paula still chose to legally contest Pratt's estate plans, likely seeking an even larger share of his $5.5 billion fortune. And after years of court battles, they reached a multi-million-dollar settlement with the estate in July 2015, though the precise terms were kept confidential. The costly court battles that ensued highlighted critical estate planning mistakes that wealthy individuals must avoid at all costs. So what lessons can we draw from Pratt's messy situation? The first major lesson from Pratt's case is the utmost importance of getting any financial promises or agreements with mistresses, extramarital children, or other non-spousal partners formally documented in legally binding contracts and trusts. Verbal assurances are not enough. They leave too much ambiguity that can lead to frivolous lawsuits down the line. And if no promises were ever made, then this fact should be documented and made clear. Airtight documentation spells out all terms and obligations, preventing any claims that don't align with your true intentions. But even putting everything down in writing is still not sufficient for fully protecting your assets and ensuring they are distributed according to your wishes after you're gone. The Pratt case exposed another critical oversight, which brings me to the second major lesson. In addition to formal contracts, every wealthy person must have a comprehensive, updated estate plan that clearly delineates how all assets should be divided among a spouse, children from other relationships, mistresses, and charities. Don't leave any room for interpretation. Your will, trust, and other documents should be explicit instructions with no ambiguity about who gets what, and any contingencies that must be met. Covering your assets in full eliminates battles. Of course, having an estate plan is meaningless if you don't take additional steps to safeguard your fortune from creditors, lawsuits, taxes, and other potential drains. Pratt's case showed the disastrous consequences of overlooking this final crucial element. Combined with an airtight estate plan, these safeguards prevent your assets from being bled dry. These are mistakes that no one can afford to make, especially those with significant wealth. Complicated family situations involving mistresses or children from other relationships, or any other complicating factors. Proper estate planning is absolutely vital for ensuring your true final wishes are carried out. Your assets are shielded and your loved ones are provided for as intended. Of course, crafting a solid estate plan is much easier said than done. It requires working with experienced lawyers and financial advisors to navigate the complex tax laws, asset protection vehicles, and legal documentation involved. Trying to draft your own will or trust is incredibly risky. One minor oversight or ambiguity and your entire estate plan could be thrown into turmoil. That's why I'd highly recommend booking a comprehensive estate planning consultation with my law firm. Our team of specialized lawyers will work closely with you to understand your unique situation and craft a rock-solid estate plan tailored to your exact needs and wishes. To get started securing your legacy the right way, click the link in the description box below to schedule your consultation.